Good afternoon, everyone, and thank you very much for joining us today. I am Michelle McGillivray. I practice labor and employment law in the Toronto office, and I'm here to present with my wonderful colleagues Shayla Klein and Ashley Mitchell. Ashley practices in our Vancouver office, and Shayla is in our Calgary and Regina offices. So just before we get started, I'm going to take a few minutes just to do some housekeeping items. You've been placed on mute due to the high number of participants. The Q&A chat is open, and you can find it at the top right corner of the screen. Please feel free to send questions at any time. We'll answer your questions following the presentations by email. And in case you need technical support, please find the help button below the video window in the right next to the return to agenda button. And lastly, this presentation is for informational purposes only, does not constitute legal advice, and please contact one of our lawyers for guidance on your specific situation. So next slide, please. So we're going to be speaking to you about harassment, discrimination, and wrongful dismissal. It is a case study approach. Next slide, please. So beginning with the fact scenario, James and Maria work at TechCo, a mid-sized software company. Maria, age 30, has been employed with TechCo for 2 years and is the marketing coordinator. She is considered a high performer and recently received a promotion. James, age 45, has worked for TechCo for 8 years and is the director of sales. Next slide. Over the past several months, Maria has been subjected to repeated inappropriate comments and advances from James. James has commented on Maria's appearance. For instance, you'd be a lot more persuasive with clients if you showed a little more leg. Made sexually suggestive jokes during team meetings. Frequently invaded her personal space, including touching her lower back during a company event. Next slide. Maria made notes of the incidents and reported them to her direct supervisor. Her direct supervisor reassured her that James is just old school and he didn't mean anything by it. The direct supervisor told Maria to try not to take it personally. The supervisor did not escalate the complaint or initiate any formal HR process. Next slide. A few weeks after she reported the incidents to her direct supervisor, Maria noticed changes at work. She was excluded from important client meetings she had previously led. She received negative performance feedback for the first time without clear justification, and James continued working closely with her despite her discomfort. Next slide. Feeling unsupported, Maria escalated the complaint to Human Resources. HR conducted a very brief and informal inquiry without interviewing all relevant witnesses. The HR manager told Maria this is a sensitive situation. James is a high-level employee and there's no concrete evidence he meant harm. HR closed the matter with no disciplinary action taken against James, and after the matter was closed, Maria was offered a lateral transfer to another department, which she felt was a demotion in disguise. And when she declined, she was told she was being uncooperative. Next slide. A few weeks after HR dismissed her complaint, Maria begins experiencing symptoms of anxiety and insomnia. She consults her doctor, who diagnoses her with work-related stress and acute anxiety, attributing it to her experiences at work. Her doctor places her on a medical leave from work and recommends therapy. Maria files a workers' compensation claim due to psychological injury caused by persistent harassment by James, lack of support from her employer, retaliation from her employer, fear of retaliation for speaking up. Next slide. Maria remains off on a medical leave of absence for 2 months. She is then cleared to return to work by her doctor. After returning to work, she finds her role has been informally reassigned and she has been moved to a less visible position. Maria resigns 3 weeks later, citing a toxic work environment and claiming she was constructively dismissed by TechCo. She later filed a human rights complaint against TechCo alleging sexual harassment and discrimination on the basis of sex. And she also filed a wrongful dismissal claim against TechCo seeking a severance package or reasonable notice at common law, as well as aggravated and punitive damages. Next slide. So I'm just now going to pass it over to Ashley, who is going to begin our discussion.
Thanks, Michelle. So I think you can probably expect that there are a number of problems with how the company handled this situation. And so we'll start off by going through and identifying where TechCo failed to follow appropriate procedures, which will then filter into some other questions about the problems and risks that this presents for TechCo. So I kind of see five major issues with how this complaint was handled by the company. Firstly, we'll focus on the dismissal of the complaint by the supervisor. Maria's supervisor ignored her formal complaint of sexual harassment. And we have to keep in mind that a complaint can be brought forward in a number of different ways, including verbally. It doesn't have to be just a complaint that's issued through a formal written complaint form or something to that extent. If a complaint is brought to the company's attention or HR's attention, it should be handled, even if more information is required in order to properly deal with that complaint. But it should be handled, taken seriously, and addressed by the company. By not addressing the complaint, the company is going to be in breach of its obligations as an employer under both occupational health and safety laws, and in this case, human rights laws as well. So not only did the supervisor not escalate the complaint or initiate any formal sort of HR process after Maria had brought it to the company's attention, but the supervisor was also really dismissive of her report. The supervisor suggested that James didn't mean anything by it with respect to the comments that were made, and that she shouldn't take it personally. Responding in this way to Maria also invalidates the seriousness of the complaint. And frankly, if employees understand that that's the way that HR is going to be handling the types of complaints that are brought forward to them, it's probably going to result in most employees being reluctant to bring forward complaints in the first place, knowing they're not going to be properly handled or dealt with. The second big issue is the lack of proper HR investigation. So the company never followed through with what Maria had brought to their attention and didn't conduct a proper investigation, even after the complaint was escalated from the supervisor to HR. HR improperly dismissed the seriousness of James's behavior and suggested that he didn't mean any harm by his actions. We know that HR did conduct a brief inquiry into the complaint, but there was no formal investigation or discussion with the actual witnesses who would help to inform the investigation and allow the company to come to some conclusions in terms of what the findings would be and whether the conduct occurred. So I think it's a big issue that no other steps were taken to address the complaint. And this would be another breach of the company's obligations under to the employer under applicable laws. So a third issue that we've identified with this fact pattern is that the no protective measures were put in place to protect Maria after she brought forward the complaint and said that she had been experiencing harassment. This is a big concern. She was required to continue working with James despite her concerns, and that put her at continued risk for further sexual harassment or other types of harassment, which is really problematic. The fourth issue is retaliation. So in the fact pattern, there was evidence that Maria faced retaliation not by her supervisor largely for raising complaint, and the company did nothing to address the retaliation even after it was brought to HR's attention. So we know that she was excluded from important client meetings that she used to take part in, and she also received negative feedback without any proper rationale or justification for it, which is really problematic and can be the root of some potential claims that could arise down the road. So, and the fifth issue that I see as being problematic in this case is a failure to accommodate by the employer. So we know that Maria had to go off on a medical leave for 2 months, and then returned to work. And she was at that time placed in a role that she felt was a demotion. And I think we have to keep that in mind, that the employer still has a duty to accommodate, and to the best extent possible, the employee should be placed back in the same position that she was in before she went on a leave, after she returns from medical leave. So this presents potential increased risk from a human rights perspective. Lastly, there was no proper resolution to this particular matter. So the company, there was nothing done to prevent Maria or other her employees from being harassed by James in the future, which is really problematic. If the company had taken appropriate steps, then there would have been, we would assume, measures put in place to prevent this type of situation from occurring again in the future. So those are the key issues that we saw, and I'll pass it over to Shayla to talk a bit about how the supervisor and HR should have responded in this particular situation.
Thanks, Ashley. So stemming off of what Ashley has just discussed, pardon me, in terms of the failures that we saw or the risks that were created from the lack of action taken by the company, how would it have been helpful had they responded instead? So upon hearing Maria's complaint about harassment, the supervisor ought to have documented it, assured her it would be taken seriously, and immediately escalated it to human resources or upper management in terms of who would conduct some kind of further investigation into this inquiry. Not only the employer, but individual supervisors are also agents, are as agents of the employer, have legal obligations and statutory duties under occupational health and safety laws across the provinces, to ensure safe workplaces, and failure of the supervisor not to address that concern in its own right is a breach of law. And dismissing it, as we heard from what Michelle went through with the fact pattern, dismissing it actually likely caused further injury. When the employee made the WCB claim and she cited the reasons for her psychological injury, one of the things was that she was dismissed by her employer and it wasn't taken seriously. And so it actually caused further injury to the individual. In terms of the human resources team, we want to see them conducting a proper investigation. So this is interviewing all of the parties, taking statements, collecting and preserving Maria's notes. It said that Maria took notes, and so we want to see that evidence collected, keep the process timely, impartial, and well documented, ensure that there's a high degree of procedural fairness, that James is given an opportunity to respond to the allegations. He's given time to reflect on the allegations and come back and speak to them. And if there's any kind of contradictory evidence or any new evidence, that the HR is going back to Maria to hear more information from her in terms of how she'd like to respond to that. And then, as Ashley said, we want to ensure Maria's safety, in particular Maria, because she's brought this forward, but James as well. We want to ensure that everybody is offered support. It can be very traumatic to be accused of something in the workplace as well. And so whether or not it did happen, we want to ensure that James as well is also supported. And that can include a variety of different things. We're considering whether these two individuals are working together in close proximity, if there's any other individuals who might also be experiencing similar harassment, and if we need to ensure their safety. In this situation, Maria is a marketing coordinator and James is a director of sales. I think it's important to consider now as well that we're not only concerned about physically having them in the room working together in the office, we're also concerned about them perhaps working remotely together and any online interactions they might have outside of the workplace, or for the workplace in terms of remote work. There was an instance where James touched Maria's lower back and invaded her personal space, but most of the other instances seem to be comments in meetings or general things that he said to her. And so we're also concerned about that online potential presence. So some administrative leave options we would typically recommend if employees can't be if we can't ensure employees' safety in the workplace because they might still be exposed to a further risk, we would recommend considering an administrative leave, typically a paid administrative leave of absence, where you are suspending an employee on administrative leave while the investigation proceeds. They're being told what the allegations are, that they're serious, that this is just something that we need to do to ensure that fairness is preserved. This is the neutral step to ensure everyone's safety and protect both parties. When we are putting someone on a paid administrative leave, obviously we want to ensure that the timeliness of the investigation is moving forward as quickly as we can. We don't want to rush anything, but we don't want someone on a paid administrative leave of absence for an extended period of time, preferably. Other interim protections, just monitoring and communicating to the employees what's going on, those who are involved in the investigation, advising Maria what's going to happen and her options, and same to James and any other witnesses. And then with that, I think we can continue to the next slide. So we're just going to talk about what kind of legal risks TechCo faces in this scenario. This is really a tight factual matrix that gives rise to a lot of different concerns, legal risks, and potential remedies and arenas for a complainant or an employee to bring forward complaints through. So first is really the human rights complaint. Maria did end up making a human rights complaint on the basis of sex and that she was harassed on that basis. Harassment can be discrimination if it's based on one or more protected grounds as defined in different provincial human rights legislation. The liability under human rights law for sexual discrimination includes like hostile work environment, reprisal. Awards can include general damages, lost wages, systematic remedies, other things. So in this space, it's possible you're facing a human rights complaint. Different provinces have different concurrent jurisdiction, whether that human rights complaint can be put in the melting pot together in the courts with a wrongful dismissal claim, or if human rights tribunals or commissions have exclusive jurisdiction over claims for dealing with a unionized employee. Typically, the preference would be that an arbitrator would handle that human rights complaint in addition to any other matters. But it's possible you might be facing multiple arenas and riding different horses. Second is a constructive dismissal claim. We heard concerns about Maria being excluded from meetings after making complaints. She was offered a lateral transfer, which she viewed really as a demotion. She was eventually stripped of her role after her leave. And all of these things typically give rise to a claim of constructive dismissal, where a employee might sue for wrongful dismissal damages, as Michelle said, in terms of severance pay or reasonable notice damages, and depending on the facts of the dismissal, also potentially giving rise to aggravated or punitive damages, which could be much higher as well. And then workers' compensation claims. So Maria made a workers' compensation claim. Her doctor diagnosed her with work-related stress and anxiety. She filed the WCB claim. Employers can't be sued for this injury at work if it's an injury that's happening in the workplace. That's the purpose of WCB legislation, to protect employers from being sued for those claims, and also to ensure employees are getting care and coverage and things of that nature. So however, there still are these after effects for employers in terms of you're having an employee who's out on leave. You need to make up for that person's work, or you need to potentially backfill on a preliminary basis. You need to work with WCB in a return to work and an accommodation process. There's a lot of time that goes into that, as well as just the dollars and cents of WCB claims do cause employers' premiums to rise. And these kinds of things can cause other intermingling effects. Finally, I'll just talk about occupational health and safety liability. So while I said that employers cannot be sued civilly for an injury, including psychological injury that's happening in the workplace, that's the purpose of WCB legislation. Under occupational health and safety law in different jurisdictions across Canada, employers have an obligation to provide a safe workplace. That includes providing systems, training, information, and other kinds of safeguards to ensure that employees are safe at work. And failure to do that may result in an investigation from an occupational health and safety officer, who may provide information typically to the province, who may lay charges against an employer or even a supervisor as an individual for failing to follow those standards. And it's a statutory penalty, and it typically can result in fines, and the fines and the significance of the fines varies across provinces, but there can also be that additional arena. And in that situation, the employee is really a witness to the Crown bringing a charge under occupational health and safety law. And so those are sort of the different arenas that could all come out of this one situation, and the different kinds of claims that an employer could be facing after this. And after that, I think we can move to the next slide.
All right, thanks, Shayla. Before we jump into this next question, I just wanted to add one piece from a BC perspective. So there's also another type of claim that can be brought in BC under workers' compensation laws or occupational health and safety laws, but you bring the complaint to WorkSafe BC. It's called a prohibited action complaint. And this kind of a complaint would be justified if an employee brought to the attention of the employer a health and safety issue, and the employee was treated adversely for bringing that issue forward as a result. So either their employment was terminated or they were demoted or they sustained some other sort of adverse treatment. In that case, the employee could bring a prohibited action complaint to WorkSafe BC, and the employer would have an obligation to deal with that complaint. The damages that would be awarded by WorkSafe BC for this type of a complaint are compensatory. So the goal would be to put the employee back in the position they would have been in had the improper conduct not occurred. So it could result in a claim for lost wages or any out-of-pocket expenses incurred by the employee as a result of that breach. So it's just something else to be aware of. And when we see these types of complaints arising with scenarios similar to what we've gone through today, often there's a multitude of complaints. So you're not dealing with just one. You may be dealing with two or three various forms of complaints and having to manage all of them. So the next discussion topic is how do workers' compensation, mental stress, or injury claims interact with human rights and employment law remedies? This is, I think Shayla touched on it to some extent, but as she mentioned, if an employee suffers a workplace injury, they can make a claim to workers' compensation and may be entitled to wage loss or other benefits as a result of that injury. And this would include an injury, like a mental health injury suffered as a result of improper conduct by the employer. WorkSafe is going to cover those costs, but as Shayla mentioned, there would be potentially increased costs for an employer just through increased premiums, and then also having to manage the claim while the employee is off from work, depending on the nature of the claim and how serious the injury is. But an employee who experiences a workplace injury can make both a claim to workers' compensation for benefits and also bring any of the claims that we've discussed so to the courts or to the Human Rights Tribunal or a prohibited action complaint if that were appropriate. There are just differences in the types of claims that can be brought in these forums, and I think Shayla's done a good job of covering those. But as it relates to workers' compensation, it's important to highlight that because an employee has the right to make a workers' compensation claim for a workplace injury, they do not have the right to sue the employer for that workplace injury. So there is a bar, and they cannot bring a court action for the personal injury that they may have sustained in the workplace. Now, having said that, it does play into the types of damages that they could be awarded in the other forms that we've chatted about. So an employee could claim aggravated or punitive damages through a court action in concert with an allegation that the employer acted in bad faith in terms of how they were either treating this type of claim or a sexual harassment matter anyways. So, and if an employer engages in bad faith conduct towards an employee that causes the employee to suffer a mental health injury, evidence of a mental health injury could result in the employee being awarded aggravated damages on top of, say, wrongful dismissal damages, or even punitive damages. So it could change the nature of the damages that the employee may get at the end of the day. And similarly, if an employer discriminates against an employee and that discrimination results in the employee suffering a mental health injury, the Human Rights Tribunal could award the employee increased damages for injury to dignity, feelings, and self-respect. So something to be aware of when you see an employee with a potential mental health injury that is related to either improper conduct by the employer or a sexual harassment incident arising in the workplace. And I wanted to also make the point that there's a possibility that an employee could bring all of these complaints while still employed with the employer as well. Now, certainly that will challenge present challenges in terms of how the employer would respond to it, but there is a possibility that someone could be off on leave and bring a human rights complaint and still remain an employee and even potentially return to work at the company. So just to be mindful of trying to manage these complaints if they are occurring and the employee remains employed. All right, next slide, please.
So just a discussion now about what kind of policies and trainings could have prevented this or aided the individuals involved in sort of dealing with this situation. So first, we'd like to highlight an anti-harassment policy. So a harassment respecting the workplace policy. Some jurisdictions require a prevention of violence policy. Sometimes we see these all together. But ultimately, it's important to remember that intent doesn't matter. It's the impact of what's happening. And so we'd like to see policies like those, and most provinces mandate these policies. And lack of compliance can create liability for the employer. Also, an investigative policy, so a policy setting out and leaving room to understand that every investigation is different. It's always fact dependent. And if you set out too formal of a policy, you might be stuck with those steps. And so you want to ensure that you have some flexibility in that, but ensuring that people know that these things will be investigated, that there'll be a level of procedural fairness. Individuals will be allowed an opportunity to respond, these types of things, to ensure a thorough, fair investigation. And then also anti-retaliation safeguards. So that may be in conjunction with an investigation policy or a anti-discrimination policy, but something setting out that there's a prohibition on retaliatory behaviors. So negative performance reviews, demotions, moving people to new positions, excluding them from meetings, following them, making a good faith complaint are prohibited. Also, an accommodation policy. This could have helped Maria in her return to work after medical leave instead of formally reassigning her. In this situation, Maria returned without specific restrictions or a modified work agreement. I'd say that's likely uncommon. Typically, you would see a more gradual return to work with restrictions, and often, especially with workers' compensation, there's an ongoing conversation between the employer and WCB in terms of how to return this person to work. WCB wants to get this person back to work as soon as they are able and they're safe to do so. And the employer might be pushing back, saying that there isn't a position, or with those restrictions, it's not possible. And so an accommodation policy can help set out those obligations. There was a presentation earlier today, which some of you may have attended, on social media in the workplace and off-duty conduct. But as I said earlier, in this situation, the harassment really was happening in the workplace, in person, in real time. However, many of these situations that we see can involve off-duty conduct or interactions that are happening between employees online, text messaging and things of that nature, or a mix of all of the three. And so setting out a social media policy for those types of expectations and making it clear that harassment that's happening off duty is still falling into these categories, still inappropriate, will still be investigated. And then ultimately providing training on these different policies, ensuring they're reviewed regularly, that they're brought to employees' attention, providing a training that is interactive or that has some kind of knowledge check and that you can have a record of. These are things that can help protect the employer and also just minimize claims in general, minimize these instances happening, and help you discipline when the time is needed. So those are our comments in terms of policies and training. Any thoughts in addition to that, Michelle or Ashley?
Yeah, I think you covered, Sheila, the key parts there. I don't know if I have anything to add on that piece.
Great.
I'm good too. Thanks, Sheila.
All right. So these are the key takeaways from what we've chatted about today. And I think it's important just to make sure that, you've got, if you receive a complaint, you take it seriously. That first and foremost. It doesn't matter if it was presented in a casual way to HR or to a supervisor, but the employer has an obligation to deal with the complaints and to investigate them properly. And so all complaints, even if they don't sound necessarily like there's a lot of substance there, should be taken seriously, and an investigation should be carried out to to determine whether or not the allegations occurred, and if so, put the employer in a better position to take appropriate action as a response. Follow your anti-harassment policies and procedures. As we've chatted about, employers are legally required to have harassment policies in place and procedures, and to follow those policies and procedures. So not only is this a legal requirement, but they're there for a good reason, to help you avoid the type of situation that TechCo got in with Maria and James, and to give you a pathway for figuring out how to deal with these situations when they do arise. Don't minimize or delay investigations. I think, again, this is really important piece. It's important that if a complaint is brought to the company's attention or an employer's attention, the complaint shouldn't be minimized, and the investigation should be carried out promptly after the complaint is brought forward, so that the employer's in the best position to gather the evidence, assess whether or not the situation occurred, and then make findings so that next steps can be carried out. It also helps to reduce risks of ongoing misconduct in the workplace if the investigation is commenced promptly. So, important thing to note. Make sure that you're protecting against retaliation. That's another very important piece. HR in particular should be very alive to the risk of retaliation, and policies should expressly prohibit retaliation so others are aware of it too, which will hopefully mean that it gets brought to the employer's attention if there are suggestions of retaliation or complaints of that nature. The next thing that is really important is to provide workplace accommodations and to support leave entitlements. So if an employee needs to be off from work for a period of time because of a health issue or another issue that's arising, especially in connection with these types of complaints, it's important to respect that and follow the accommodation requirements under human rights laws, and allow those types of leaves if they're justified in the situation. Maintain appropriate documentation is also crucial. We've touched on that a few times throughout today's presentation, but employers should do a really good job of making sure that all steps of a complaint process are well documented, including any report of an initial complaint, the steps taken to investigate the matter, and the steps taken at the end to address the matters as well. Because if you are faced with a number of complaints or even one complaint or claim at the end of the situation, being able to go back and have documentation to help support the steps taken by the employer will put you in a much better position for defending those claims or complaints. And so appropriate documentation is very important. So those are the key takeaways for today, and I will pass it back over to Michelle now.
Okay. Thank you, Ashley. As I mentioned, the Q&A chat is open, and you can find it at the top right corner of your screen. So please feel free to put in your questions following the presentation. We'll follow up with you by email. In the meantime, however, we receive a lot of questions from clients about these topics. So we thought we would just discuss some of the common questions we receive. So I'm actually going to talk a bit about the question that I have received a couple of times in the last couple of weeks, and then again today after seeing our slide presentation, is must all workplace investigations be referred to an external workplace investigator? So the answer to that is no. Depending on your internal resources, they can be conducted internally, and as both Ashley and Shayla talked about, it's important to have a workplace policy addressing workplace investigations so that they can be done internally. But as you saw from our fact scenario and heard within the presentation itself, there are a number of nuances that can come up within these circumstances. So we do recommend that you reach out to one of us or your contact at Miller Thomson to see whether or not we would suggest that you do take steps to retain an external workplace investigator before conducting the investigation. So Shayla, Ashley, do you?
I was just going to add to that, that I think Michelle's point as well is that you're needing to follow your policies, and often that is going to attract potentially additional damages. So for example, if you have a policy that says that you're always going to provide a third-party investigator, I mean, that's going to be a higher standard, definitely. But if that's what your policy says, then to not do that would be in breach of your own policy and could attract additional damages and scrutiny. We wouldn't say that you need a policy that says that. As Michelle said, some can be conducted in-house. But just as an example, in terms of following those procedures, it could be that the individual is always going to be provided. Sometimes we see some that say the individual will be provided a copy of the preliminary report following the end of the investigation, and then they'll be able to provide additional comments. Again, not all investigative policies and procedures are the same, but if that's what your policy says, you need to follow it, or you may attract additional damages.
I think I don't have any further comments on that particular point, but just wanted to address another issue that we sometimes face with these types of fact scenarios. So it's not infrequent for an employer to come to us once they've already received a number of different claims in the different forums. So like if they perhaps a notice of civil claim has been filed as well as a human rights complaint, and they may also be dealing with a workers' compensation piece, and they're coming to us for advice on how to deal with it. And just want to encourage you to not hesitate to reach out, because there are certain strategies that we can implement or to help you implement to reduce the risks of having to defend actions through various different forums. And so depending on the circumstances, if the same types of claims are being brought or addressed in, let's say, a civil claim as well as a human rights complaint, then there may be an opportunity to get a stay on with respect to one of those claims, so that you're not having to deal with both of the claims concurrently, and especially if there's going to be a risk of different findings in the different cases. And so that's something to consider. There's also a possibility of bringing an application to dismiss, particularly a human rights complaint, if maybe there's not enough substance there for that complaint to proceed, or perhaps also an option is to consider early resolution of the matters if it looks like it's going to be too complicated to defend them all. And so we're happy to work with you on various strategies depending on the fact scenarios and what you're having to work through in these types of cases.
And on the note of early resolution, I think it's important. Sometimes these files can resolve quite early, but because of the nature of all of the different kinds of claims, we really want to ensure that the employer has a fulsome release that includes all of those different types of claims, and specifies them in favor of more of a general release. We want to list all of those different kinds of arenas to really make sure that you're in the clear. Another comment I was going to add, that we didn't discuss in this presentation, is that there's also potentially the option that during all of this, the employee is on a short-term disability leave or a long-term disability leave, or just a general unpaid medical leave of absence provided for under employment standards legislation. Well, not really like another arena, it's just an added process that employers might be dealing with in concurrence with the others as well. And so I highlight that for you in addition. And if those premiums or those health benefits and things are not covered, sometimes those are additional things we can see included in claims is the cost of counseling, the cost of care, and the things associated with that.
Okay, thank you, Sheila. Ashley, do you have any additional comments to that one?
No, I think that's
No?
it.
Okay, great. Well, thank you everyone for attending. I'm going to have you click the Return to Agenda button, and you'll be directed back to choose your next session. And like I said, if you have any questions, feel free to reach out, put it in the chat, and our contact information is also on the agenda. Thank you very much.